May I call the next matter, Paul?
Calling matter number 3 on the urgent roll, UM 258 of 2023, Daniel Lotte Vickers van der Paper versus Companies and Intellectual Property Commission and 6 others.
Good morning, my lady. May it please the court, my surname is Botes, B-O-T-E-S. I'm a member of the Pretoria Society of Advocates, and I appear on behalf of the applicant under the instructions of Mrs. Barnard Patel, Incorporated in Pretoria.
Good morning. Good morning, Mr. Botes.
As it pleases the court, my lady, I appear on behalf of the 3rd, 5th, 6th, and 7th respondents in the main application and the 2nd respondent in this urgent application, being the jointly appointed liquidators and the insolvent company Terrio Mix. And it's Mr. Hershenson, and we are here on instruction of Stradom and Rabi attorneys.
Mr. Hershenson, can you just confirm again the respondents you're appearing on behalf of? Is the third?
It's 3, 5, 6, and 7 of the main application, and the 2nd respondent in this application.
Say that again.
So 3, 5, 6, and 7 in the main application.
In this application?
And this application, it's the 2nd respondent. They cited simply as the insolvent company.
I see. And which other respondent in this proceedings?
See Mr. Fanekak's on mute, my lady.
Yes, he's on mute. I'm just establishing from you, Mr. Hershenson. So it's the 2nd respondent, and which respondent? Just the 2nd respondent in this.
Just the 2nd respondent in this application, being the insolvent company, my lady.
My lady, I don't know if your ladyship can hear me now.
Loud and clear,
As it pleases you, as it pleases you, my lady. I'm Van Niekerk, my lady. In this application, I appear on behalf of the 3rd and the 4th respondents. I've been instructed by Walter Niedinger attorneys.
Thank you, Mr. Van Niekerk. The 5th, 6th, and 7th respondent, is there anyone appearing?
No, my lady, there's no appearance on behalf of the 1st respondent, that is the CIPC. There's no appearance on behalf of the 5th and the 6th respondents, and there's also no appearance on behalf of the 7th respondent before your ladyship.
Yes, very well. Mr. Botes, you may proceed.
Thank you, my lady, and thank you for the opportunity. Just allow me, for purposes of good order and housekeeping, just direct your ladyship's attention to the status of the application. We trust that your ladyship has been placed in possession of the application itself, as well as the service and compliance affidavit, and as well as our practice note and our draft order. So just to start off with what is important is the service of the application, and that your ladyship will find in the separate division, and that is called the service and compliance affidavit section, which contains pages 1 up until page 101. And what is important of that service and compliance affidavit is, on a proper reading thereof, it is evident that the application was served on all the affected parties, on all the respondents, specifically the 1st, 2nd, 3rd, 4th, 5th, 6th, and 7th respondents, and that the service, my lady, all took place on the 18th and on the 19th of December, and that is, there's also a notice of set down that's also been addressed and transmitted to all the respondents concerned. Pursuant to service, we only received a notice of intention to oppose on behalf of the 3rd and the 4th respondents, that's Mr. Van Niekerk's clients, And the liquidators, Mr. Hershensen's client, that is the second respondent, they abide your ladyship's order, and the notice to abide your ladyship will find in the service and compliance affidavit from pages 95 and onwards. Page 95 and onwards, and that notice to abide, my lady, was already filed on the 19th of December 2023. So what we submit to your ladyship is, from a procedural perspective, the application is before your ladyship insofar as service and compliance is concerned. May I just move to the second point, and that is the relief which the applicant applies for, and it's important to direct your ladyship's attention to the notice of motion, and more specifically paragraph 2 thereof. What the applicant applies for is that the Companies and Intellectual Property Commission be directed to amend or restore the second respondent's official status in its records as in liquidation. Yesterday, I requested my instructing attorney, who is sitting with me in my chambers, just to access the official records of the first respondent so as to get an update whether or not this first respondent did already attend to the amendment of the status, because your ladyship would have recalled that the first respondent gave such an indication already on the 14th of December. This yesterday afternoon, my lady, it's still reflected in business. However, my lady, this morning, when I walked into my chambers and my attorney and I greeted each other, he presented me with a printout of the second respondent's official status as it is reflected on the first respondent's database. And just allow me to do this, my lady. It reflects there where I've made the arrow in provisional liquidation. So it seems that what transpired from yesterday afternoon until this morning is that the first respondent did indeed comply with its undertaking, and I just for purposes of cross-reference, ask your ladyship just to make the following note in your ladyship's bench book. That undertaking your ladyship will find on page 80 of the paginate, page 880, page 80, that's Annexure FA12. And that is the document which the first respondent transmitted to Mr. Hershensen's client's attorney, in which the first respondent said already on Thursday, the 14th of December, and I read to your ladyship verbatim, where the first respondent says, CIPC will proceed to nullify the filing of the business rescue and inform the company accordingly. And then it says it's crucial to clarify that the provisional liquidation court order was never submitted to CIPC to amend its records. Hence, the assertion that the company status changed from liquidation to business rescue is inaccurate. May I just add, for good order and procedure, the first respondent's assertion in this regard, my lady, is 100% correct, because that is also in line with the provisions of the Companies Act and also in line with the judgment of His Lordship, Mr. Justice Deppener, which we've attached to our practice note, which we trust your ladyship had sight of. So, all things equal, in accordance with the provisions of section 129 2A of the Companies Act, there's a prohibition on the institution or the commencement with business rescue proceedings under these specific instances. So what we submit to your ladyship as officers of the court, what the applicant wanted to achieve, in other words, what the application was aimed at, it seems that there was compliance this morning. So insofar as that aspect is concerned, my lady, I don't think that it is, or my submission is, that it will be superfluous to proceed with any relief against the first respondent by virtue of what I've just conveyed to your ladyship.
So that would obviate prayer 2, and only prayer 2.
Yes, my lady, and to a large extent, from a procedural point of view, it goes by implication that it strikes at the heart of prayers 3 and 4 as well, because everything that it's a domino effect. Once the status has been restored or amended, then the resolution per se, in terms of which this decision was taken, well, that
Will
falls
be of no
outside.
effect.
It is so, yes, my lady, it is so. So what remains in our respectful submission, still in dispute from the applicant's perspective, is the costs of the application. Your ladyship would have noted that the applicant does not ask for a cost order against either the second respondent, Mr. Hershensen's clients, or the first respondent, the CIPC, for good reason, but only against the third and the fourth respondents. Those are Mr. Van Niekerk's clients. And there's adequate grounds and reasons why that is pursued with, and I'll get to that in a minute. However, have your ladyship received the third and the fourth respondents' answering affidavit? That affidavit was disseminated electronically last night, just before 8, to my attorneys, to myself, and I assume to Mr. Hershensen's clients as well. And that should form part of your ladyship's reading bundle from page 105 up until page 191, and may I add, only 18 pages thereof constitutes evidence. So to a large extent, it's annexes which, in our view, have been attached as a red herring, and it doesn't contribute to what the applicant want to achieve. But be that as it may, Mr. Van Niekerk will address your ladyship in that regard. But what is, however, prudent from a proper reading of the respondent's answering affidavit, there appears to be 5 issues which the third and the fourth respondents pursue, and which we are duty bound to address before we get anywhere to the merits or to the costs of this application. And if your ladyship will allow me to paraphrase what the third and the fourth respondents say in limine, is the following. 1, the application lacks sufficient urgency as provided for and envisaged in Rule 6.12 of this court's rules. Secondly, the applicant lacks locus standi in judico to initiate this application. In the third instance, your ladyship doesn't have jurisdiction to entertain this application. And in the fourth instance, my lady, there's a plea of lis alibi pendens. And what we've identified as the 5th issue is the issue pertaining to costs. So if your ladyship will allow me, I'll be brief on these issues, because each and every of these points taken by the third and the fourth respondents have absolutely no merit. We respectfully submit that they are fundamentally misconceived, they're bad in law, and it's simply a strategy or a mechanism embarked upon by the third and the fourth respondents to disguise their own illegal and unlawful conduct. So let me start.
Mr. Borges, I'm going to ask you to pause, because you may notice that I have been, searching diligently for the answering affidavit.
Oh, sorry, my lady. Yes, it's important for your ladyship to have it in front of your ladyship.
Yes, which appears to me that it raises certain points in limine.
Correct.
Importantly, the issue of jurisdiction.
Yes.
And given that, I think it would be prudent of me then perhaps to dispose of that,
Very well.
first. Yes, first and foremost.
Very well. I agree with you,
because then it might be a futile exercise should this court find, you know, that it agrees with the respondents in that regard.
My lady, I agree with your ladyship, yes.
Yes. Perhaps I may just establish, yes, Mr. Van Niekerk, you preempted what my inquiry is going to be. The answering affidavit, was it made available? Was it filed? And at what time? It has not made its way to me. And I accept that is the nature of these proceedings when they head electronically. Yes.
My lady, I understand the judge to whom the matter was allocated has changed. It was originally sent to the original registrar. However, my lady, this morning at 9:34, when we noted that your ladyship will hear the matter, it was sent to Fancy Mashaba. My lady, the email address, I don't know if Mr. Mashaba would have to confirm it.
It will be Mashabi. Does the email address read Mashabi?
Apologies, my lady. It's the font is small on my other screen. fmashabe@judiciary.org.za. So, my lady, it was sent this morning at 9:34 to your ladyship's registrar. I don't know why it hasn't reached your ladyship yet.
Yes, I have received a few emails, but not this one. There we go. Just came in now.
As it pleases you, my lady.
Yes, as I've indicated to Mr. Borges, I think it would be prudent if I give an opportunity to you to address me on the points in limine, particularly the issue of jurisdiction. And I think perhaps for good order, it would be prudent for you to proceed with the points in limine, all of them, so we don't necessarily do a back and forth.
As it pleases you, my lady. My lady, just for clarity's sake, would it not be most prudent to start with the effectively last point in limine, which is urgency?
Yes.
And then take it from there, my lady.
Yes, would I, if this court finds that it doesn't have jurisdiction, would it have jurisdiction to entertain the matter even on an urgent basis?
As it pleases you, my lady.
Yes.
My lady, I don't know if your ladyship has the opposing affidavit now open before your ladyship.
Yes.
To start with the point in limine of jurisdiction, which is point 6. It's at paragraph 6 with its subparagraphs.
Yes.
As it pleases you, my lady. Now, my lady, as my learned colleague already indicated, the relief that they persist with seeking today is against the third and the fourth respondents. The horse had bolted on the other issues, and my lady, I'll get to that when arguing urgency as to the premature nature of enrolling the matter. But my lady, at paragraph 6.4, the third and fourth respondents state that I reside in Bronkhorstspruit, Gauteng, and the fourth respondent resides in Gauteng, and her work address is given. My lady, these respondents against whom relief is sought, and effectively the only parties against whom relief is sought then today, don't reside or work within the area of jurisdiction of this court.
Yes, let me interject there. If you consider the fact that when the proceedings were brought initially, relief was sought against all respondents, including the first respondent, the fifth respondent, sixth respondent, and the seventh respondent.
My lady, the first respondent, the CIPC,
yeah,
I don't know where their head offices are, my lady, but the relief sought against them is moot. Now, my lady, I'll get to that. I don't want to.
As of when?
My lady, if as my submission would be, as of from the 14th when my learned friend said that they received the undertaking that the amendment would be made.
Yes, if one considers that after the undertaking was made, there was never compliance on 2 occasions. When the status of the first respondent changed to, before it wasn't business, it changed to
Provisional.
Provisional liquidation. No, on the 18th of December, it changed to in business. This is now subsequent to the undertaking. What should we make of that?
My lady, I take your ladyship's points. However, at paragraph 6, and I understand that your ladyship hasn't had an opportunity to read the answering affidavit because you just received it. The submissions are made, or at very least allegations are made. In 6.1, it says, I deny that this court has jurisdiction. 6.2, the main relief sought by the applicant is an order against the first respondent to amend the official status of the company. That was the main relief, that's now passed. 6.3, the setting aside of the resolution which was taken in Pretoria, as well as any orders affecting the 5th and 6th respondents, are merely and similarly relief. And they conduct business in Pretoria. My lady, and then 6.4 states that the parties reside in Gauteng, Pretoria. So it would then effectively have to come down to a question of where the CIPC's registered address is, my lady. Because all the other parties against whom relief is sought are in Pretoria.
Yes.
So, my lady, it's unclear on what basis the jurisdiction should then be vested in the Northwest.
Yes. What am I to make of the fact that 2 orders were granted by this court, including the order granting the provisional liquidation of the second respondent? What am I to make of that?
My lady, I don't see regarding that other order any relation to the proceedings here today.
How so? The proceedings today relate to the fact that the second respondent is in liquidation, has been placed in provisional liquidation by an order of this court. Not only that, but there were subsequent proceedings in November where judgment was reserved. However, the rule nisi was then extended. How so? How can there be no relationship if the crux of the matter is that the second respondent is in fact in provisional liquidation placed in it by this court? How is that of no relevance?
My lady, if your ladyship takes the view that the other matter is relevant, then my lady, perhaps the jurisdictional point in limine might have some issues. However, the Locus, standi and alibi pendens points in limine will then greatly benefit from that, my lady.
Disposes of the issue of jurisdiction. I'm inclined to agree that this court has jurisdiction on the basis of the what I've proposed to you, Mr. Van Niekerk.
As it pleases you, my lady. Lady, I don't know if your ladyship would then want me to proceed with the other points, or if your ladyship would then want to hear urgency first.
Yes. The issue of urgency, yes.
My lady, should I then allow my opponent to go first?
Yes.
As it pleases you.
Thank you.
My lady, just on the issue pertaining to jurisdiction, may I just ask your ladyship just to make a note? The jurisdiction aspect has been canvassed comprehensively in paragraph 9 of the founding affidavit under the heading Locus, standi and jurisdiction. But there's a more important aspect, and that's an aspect which will eventually also have some emphasis and some application in the end of the day when your ladyship has to exercise your discretion insofar as the cost is concerned. May I just ask your ladyship to turn to page 14 of the bundle, and what appears from that, my lady, is compelling. In paragraph 9.2, the deponent says the second respondent's registered address is still situated within this court's area of jurisdiction. Just pause at FA1, we'll get back to it. In 9.3, the third respondent, that's Mr. Liebenberg, reportedly resides...
I've disposed of the issue of jurisdiction, Mr. Portis.
Very well.
That issue has been disposed of.
Very well, then I accept that. Let's get to the urgency.
Yes.
It is expected of a litigant and applicant in these proceedings to persuade your ladyship that the matter is sufficiently urgent and that your ladyship will find application in terms of Rule 612B. And the urgency, my lady, your ladyship will find under the heading urgency from paragraphs 23 and onwards. In a nutshell, my lady, a concursus creditorum was established on the 23rd of February 2023 pursuant to the order that was made by your sister, the Honorable Deputy Judge President Judgy, and that was on the 23rd of February 2023. Pursuant to that constitution of a concursus creditorum, it led to the return day being anticipated, and then eventually it became before your brother, His Lordship Mr. Justice Morgan, on the 13th of November 2023. So what happened on the 13th of November 2023 is that the matter was comprehensively ventilated and canvassed by all the legal representatives, and judgment was reserved. Unbeknown to anybody, no notice was given, no heads up was given. The third and the fourth respondents, we submit, surreptitiously went and adopt a resolution so as to commence with business rescue proceedings and placing the second respondent under supervision in accordance with the provisions of section 129 of the Act. That all was done on the 6th of December. On the 8th of December, that resolution took effect within the official records of the first respondent, and the day upon which the liquidators became aware of this was on the 13th of December, 13 December 2023. And immediately, my lady, correspondence were addressed to the CIPC, and that your ladyship will find on page 73, FA9, and more importantly, my lady, to the business rescue practitioners, that is the 5th and the 6th respondents on the same day, that's on page 76, FA10.
Let me assist, I think, in the interest of time as well, Mr. Portis, and expedite this.
Yes.
What I understand the respondents, and this is now the third and fifth respondents' issue to be, is that when you were given an undertaking, when the applicant was given an undertaking, that no business rescue steps or activities would take place until the 8th of January 2024. It then obviated the urgency of the matter. That is what I understand their case to be. And I think perhaps you should, in addition to whatever other submissions you want to make, but if you can simply focus on that, because that seems to be the opposition.
They've got 2 points in this regard, and that's what I was aiming at. The 5th and the 6th respondents, my lady, they gave an undertaking which your ladyship will find on page 79. So upon the receipt of the liquidator's attorney's letter, they said, and they say so, if your ladyship is on page 79, annexure FA11, they say in paragraph 4, Mr. Nordier is however prepared to give an undertaking that he will not act as the business rescue practitioner until the 8th of January 2024. Accepted. Then on the 18th of December, so everything is now fine. Everybody, there's peace in the village. Everybody is comfortable. Everybody is satisfied. Then on the 18th of December, and this is what triggered the urgency, and it seems that our learned friends cannot or don't want to accept the factual reality. On the 18th of December, which your ladyship will find in paragraph 24 on page 25. The applicant's attorney accessed the official databases basis of the first respondent, and it was still reflected as in business rescue. That is on paragraph 24. And then, and the word is used bizarrely, on the same day, later the same day in the afternoon, somebody, we don't know who, changed it from business rescue to in business. So that means that the original status quo, which antedated the order that your sister, the Honourable Madam Justice Judgy, gave on the 23rd of February, was all done away with. That means that this entire business enterprise vests in the hands of the third and the fourth respondents. And that, my lady, is of extreme concern, because nobody anticipated that. Don't ask me how, because we can't explain it. We thought that the third and the fourth respondents would explain this to your ladyship. How on earth can it be reflected as in business? But my lady, that was then followed up, and it seems that simply the first respondent only then got wind of what the applicant wanted to achieve, and this morning the record was amended or rectified as in provisional liquidation. And may I add, was this application not initiated, then the status quo would still have been in business. And may I submit this to your ladyship, we are dealing with, on the second respondent's version, with more than 30,000 investors who invested money into this entity, the second respondent, and again on the second respondent's version, we are dealing with substantial amounts of public money exceeding 1 billion rand. And if your ladyship has regard, and it's not necessary for purposes of this exercise, the evidence in the main application is that there's a substantial shortfall. Not only that, but if your ladyship has regard to the report that was filed by the Commissioner of the Insolvency Inquiry, there are various transgressions. So the application was absolutely necessary within the ambit of what transpired since the 14th of December. In other words, since the CIPC indicated that they will attend to the amendment, since the 5th and the 6th respondents indicated that they will hold their horses, the whole apple cart was overturned by the subsequent events, which we submit opens the door not only for abuse, but for serious economic and commercial repercussions. And just if your ladyship will allow me, may I direct your ladyship's attention to a very well-known judgment which deals with this type of urgency. That's the judgment of His Lordship Mr. Justice Goldstone. Your ladyship knows this judgment. I'm not going to read it to your ladyship. That's the well-known judgment of 20th Century Fox versus Black Films. And just for your ladyship's convenience, the reference is 1982, 3 SA 582 in the WLD. And what His Lordship Mr. Justice Goldstone says on page 586 against the letter F, he says, in my opinion, the urgency of commercial interests may justify the invocation of Court Rule 612. No less than any other interests. Each case must depend upon its own circumstances for the purpose of deciding upon the issue of urgency in this matter. I must assume, as I have to, that the applicant's case was a good one and that the respondent was unlawfully infringing the applicant's copyright in the films in question. So in order for your ladyship to have regard to whether or not the application satisfies the jurisdictional milestones of urgency, your ladyship must be satisfied that the applicant's case, insofar as the issue pertaining to the status of the second respondent is concerned, is a good one. And it's impossible to make any submission that the applicant would not have obtained substantial redress in due course. Once the horse is bolted, and once it appears that in the official records of the first respondent, all of a sudden it changed from business rescue to in business, my lady, it became substantially urgent and compelling to rectify this obvious wrong. But you cannot leave it just for the sake of or in the light of the undertaking given by the fifth and the sixth respondents. So what we submit is this is one of those instances which falls on all squares within the 20th century Fox judgment of His Lordship Mr. Justice Goldstone, and would the applicant not have proceeded with this application on an urgent basis, I'm afraid that it would have had significant and adverse financial results insofar as the management, the control, and the concursus creditorum is concerned. Yes. The application is urgent, my lady.
Yes. Once again, I want to expedite these proceedings. I would like to detain anybody here unnecessarily.
Very well.
Given the fact that you have made submissions to the effect that the relief that is sought has been obviated to a very large extent, perhaps in totality.
In its entirety.
Yes. Except for the issue of the issue of costs. Correct. Wouldn't it be prudent then? I see Mr. Hescherson, he is raring to go. But yes, that the respondents give their submissions. I've quickly read through the answering affidavit. And it does appear to me that the third and fifth respondent rely only on the points in limine. Everything else is a denial of the orders that were granted by this court, denying everything. Am I correct then to presume that you would not have any submissions to make necessarily in respect of the relief that you're seeking, because in your view that has been obviated by this compliance, belated as it is?
My lady, there's two submissions. One was the order which your ladyship will find attached to the founding affidavit, and that is the order in terms of which His Lordship Mr. Justice Morgan, but in so many words, extended the rule nisi until FA2 of his judgment. So
yes, which is also denied.
On what basis? I mean, there is the court order. If one has regard to the authorities and more specifically Ouderkraal, the order stands until it's set aside or it's varied or it goes on appeal or discharged. So, but even so, even if there wasn't an order, I think what Mr. Van Niekerk, and I don't want to be facetious and I don't want to be sarcastic. The application, the original application that served before your sister, the Honourable Madam Justice Judge, is still an application. It has not been, it's not been dismissed. It's not been dealt with in any other fashion. And that falls squarely within what we submit. His Lordship Mr. Justice Weppener ruled that there's still a prohibition. So even if there was no order by His Lordship Mr. Justice Morgan on this specific terms, we would still have been entitled to initiate this application and to apply for this relief.
On the basis of the February order?
Yes, 100%. It seems that, and I don't want to put it higher, it seems that Mr. van Niekerk and his clients is confusing the issue entirely. It's got nothing to do with whether or not the order was, in so many words, extended or not by His Lordship Mr. Justice Morgan. It is the fact that there's a pending application for the winding up of the second respondent. Whilst that procedure has not yet been pronounced upon, there's a prohibition. You can't do it, even if you want to do it. And that seems to me that the penny hasn't dropped with the third and the fourth respondents, that what they have done, my lady, is simply illegal and unlawful. It contravenes and it violates the provisions of the Companies Act. I mean, I can't put it clearer. And there's no authority, and Mr. van Niekerk is not in a position and will not be in a position to provide your ladyship with any authority in support of his submission in that regard. So what we have done is we've attached to our practice note as Annexure Y the judgment of His Lordship Mr. Justice Weppener. And may I just ask your ladyship also to expedite the summary of what we want to drive home. Your ladyship will find in paragraph 43 of his judgment, and His Lordship Mr. Justice Weppener says it's a one-liner. He says, Section 129(2)(a) of the Companies Act expressly prohibits the adoption of a resolution to place a company in business rescue if liquidation proceedings have been initiated against the company. Full stop. There's the answer. It needs not be driven any further. And I agree with your ladyship. What the third and the fourth respondents' attitude is, there's a blanket, a general, a sweeping denial of everything which transpired for a reason, because it doesn't suit them. It doesn't suit them to accept the reality that the courts have dealt with and pronounced upon. And that is why you get this impression by in the answering of the answering affidavit that they've been subjected to this public media witch hunt, and for that reason alone, they should be absolved. They cannot be absolved. They must put facts before your ladyship, so as to enable your ladyship to exercise your judicial discretion. Those are our submissions in that regard.
Thank you, Mr. Portas. Mr. Hashimson?
Milady, we obviously abide the decision, and I intend to be frank, and I intend to be even briefer than I am frank. And Milady, let me start with the following. What we are in essence dealing here with is a dishonest and contemptuous resolution which was filed in fraud of this court, Milady, in fraud of the SIPC, and in fraud of all the investors. And that in its essence is what this is. If one looks at Mr. Liebenberg's affidavit, which supports the resolution, putting the company in business rescue, he makes a blatant and fraudulent misrepresentation that the liquidation had lapsed. Now, milady, a fraud which is made in such blatant terms and by a party who disregards any order of a court, which was the one given on the 14th or the 13th of November, is a party who needs to be brought to book urgently because it is in contempt of this court. And secondly, milady, I doubt that any other action other than a finding by your ladyship that this was a fraud and was in an illegal resolution filed will put, or should I say, will slow down Mr. Liebenberg in his momentum that he believes he has achieved with this inaction. So we would submit, milady, in those circumstances that when a court is dealing with such a serious fraud as we are here, that the court needs to take urgent action, that the court is required to stamp its authority on these circumstances and to show its disapproval of the type of behavior which is being exercised here. And in those circumstances, milady, and I find myself making these submissions from my holiday home in the Western Cape, that should be an indication that we are serious about this matter, and we would not lightly entertain this, milady, if it was not for these serious and fraudulent misrepresentations made. So, my lady, we would submit that this matter is urgent. It is urgent in the utmost degree, and insofar as we abide by the decision, we believe that, unfortunately, your ladyship would be required to make some sort of finding regardless of what has happened in the interim, lest we find ourselves back in court again after Mr. Liebenberg has twisted the truth on something else in future. Unfortunately, that is the state of affairs in this estate as we have experienced. Lady, those are our submissions on the urgency of the matter.
Thank you, Mr. Hershenson.
May it please you, my lady.
Mr.
Lady,
Van Niekerk.
We've now dealt quite a bit with merits, my lady. However, the issue of urgency is still before your ladyship, and my lady, for that, I'll begin by stating the question that this court has to ask is not based on, as my learned friend Mootness stated, whether the applicant was entitled to enroll the application. He made quite a meal of the fact that the applicant was entitled to enroll the application because of the conduct or the actions taken. Lady, that's not the question. Entitlement is not the question. The question is whether the applicant is entitled to enroll this application on 40 somewhat hours notice.
Why not? Why not? You've heard the submissions that were made by both counsel. Your colleagues say this is fraudulent. It has to be stopped. It is a blatant disregard of a court order, not one, but two court orders. Not only that, but the affidavit that is deposed to by Mr. Liebenberg in relation to the business rescue, to the CIPC, the first respondent, is totally false. Why should the court not intervene urgently? I apologize.
As please, my lady. My lady, now, that was the submission made by my friend Hershenson.
Yes.
Who said that there is fraud. My lady, that's again a question of the merits, and that doesn't go to the urgency of enrolling the matter on 2 days' notice. It's an extremely urgent enrollment, my lady. So, my lady, to answer to that, the first hurdle in this court, which is the urgent court, is the issue of urgency.
Yes.
So, my lady, it seems to me, and I don't know if I misunderstood my colleague, that the second, third, and fourth prayers are effectively now moot. I don't know if I misunderstood that, my lady, but it seems that we are now persisting on the issue of costs.
Yes, as of today, as of today. But I would presume that you don't agree with that because you are opposing the matter on the basis of urgency and on the merits.
Yes, my lady. Now, my lady, if the court can't grant orders which are moot, and the court is simply asked to entertain prayer 1 and prayer 5, which is that the matter be heard as urgent, and then that the costs should follow, my lady, then my submission in that regard would be that costs are never urgent. And my lady, that's in the matter of Laga versus Shell Auto Care.
No, I'm going to interject. First,
Yes.
let me put this to bed. The third and fourth respondents, your clients, are third and fifth.
Third and fourth, my lady.
Third and fourth. Are opposing, if I understood your submissions correctly, the urgency only based on the degree of urgency. Not that the matter is not urgent, but
No,
not so urgent as to be brought under, these extremely abbreviated timeframes. Did I understand you correctly?
No, my lady.
Yes.
My lady, the argument's not only that the matter shouldn't have been brought on extreme urgency. The argument is that the question whether substantial redress could be afforded in due course has been answered when that substantial redress was afforded without this application even being heard, my lady. The substantial redress that the applicant sought was fully complied with, was provided to them without this court's intervention.
But was it provided urgently by whoever provided that redress? Was it done urgently?
My lady, it seems so, as it was done before this court was even hearing the matter. This court is hearing the matter urgently, my lady, And that relief was given even before the court.
When was that relief given? As of
This
today?
morning,
Yes.
yes, my lady, this morning,
Mhm.
which, my lady, is substantial redress.
I see.
It's not only that there was relief given or that there was a delay in the relief given, which an undertaking was given on the 14th. It's the fact that substantial redress was afforded.
I see.
Not can be. Now, my lady, I won't repeat my submission of earlier where I stated on the 14th, the applicant already knew that he will get substantial redress by compliance of the first respondent when the undertaking was given. My lady, but he then sought to prematurely launch this application on an extremely urgent basis, only for the relief to become moot on the morning that the hearing should take place.
Yes, but I don't know if I'm following you correctly. Prematurely, is it when? When was the application? This application brought. How
Maybe
could
as
it
I
have?
understand it was on Tuesday.
Yes, how could it have been premature at that stage when the substantial redress that you refer to had not been provided? Was not the substantial redress provided because of this application? Urgently, as you had submitted. Sorry, yes.
My lady, there's absolutely no indication or proof that that is the case. There's nothing that shows this court that the first respondent wouldn't have taken this step if not for this application. The first respondent didn't come to court to take up the task of answering that question, my lady, but the only thing that can be done is an inference can be drawn, but that inference would be misplaced, my lady, because on the 14th, they already said they were going to do it.
Which they did not do. Which they did not do on two occasions thereafter. First, after having given that undertaking, then the status of the company is in business rescue. And then thereafter, it's in business. And would it have been necessary at all for the first respondent to have to do anything had it not been for the conduct of the third and the fourth respondents?
Well, my lady, to that, the answer lies with the first respondent. Lady,
the answer was?
Lies with the first respondent. My lady, the question here, perhaps, my lady, I can...
How so, Mr.? I'm not. I don't think I'm going to entertain you for long on, in this line of argument. How so? When the evidence before this court is to the effect that this was triggered, whatever action that was taken by the first respondent was triggered purely by the conduct of this third and fourth respondent.
My lady, the conduct took place at a stage when the first respondents didn't have the company's status listed as such. Now, my lady, the first respondent said on the 14th, we will amend it. We will correct it. My lady, it wasn't done on the same day. It wasn't even done on the day after. However, my lady, it was done. It was done today.
After the application had been brought?
Yes, my lady.
Yes, and then therefore your submissions are?
That substantial redress was already afforded. Now, my lady, for that, perhaps I should just refer to case law, my lady, as my learned friend did. The tried matter of East Rock Trading versus Eagle Valley Granite, my lady, which is...
Yes, that's on a case-by-case basis. It's not a sweeping statement. What is substantial redress in the peculiar circumstances of this case? What is substantial redress? When an application is brought and nothing is done, the opposite is done. What is substantial redress at that stage? Let's take it stage by stage, not only at the tail end, when at the doorstep of the court. What is substantial? Did they have substantial redress? So you're saying they didn't have substantial redress at the time that the application was brought, but they do have substantial redress now, and it has been afforded, and therefore costs?
My lady, I'll restate what I said earlier regarding costs. Costs are never urgent. It should always be placed on the normal roll.
Which court should be settled with that with the issue of cost one, for what purpose at a later stage when the facts of the matter are now before this court?
My lady, I'm merely stating what the case law states, my lady. It says that costs aren't urgent and it should be placed on the opposed role in the normal course, if that's the only issue that remains, my lady.
Am I understanding you to be saying that the third and fourth respondents' posture is that they are opposing the issue of costs?
Indeed, my lady. The application in its totality is opposed. However, it seems to me as if we're only opposing now the issue of urgency and costs because the horse had bolted for prayers 2, 3, and 4. That's my understanding of the matter, my lady. I don't know if your ladyship disagrees with me in my understanding of the matter.
I hear you, Mr. van der Kerk.
My lady, as it pleases you, my lady, I think it's crucial that I know that I'm not misunderstanding your ladyship in that regard. However, my lady, with my reference to the East Rock Trading versus Eagle Valley Granite, my lady, the specific portion in that judgment where it says the correct and crucial test is whether if the matter were to follow its normal course as laid down by the rules, an applicant will be afforded substantial redress. And if he cannot be afforded substantial redress at hearing in due course, then the matter qualifies to be enrolled as urgent. Now, my lady, there is no question even more of whether substantial redress can be obtained in due course, because that horse had bolted. Substantial redress was obtained. Lady, so, and this is merely my submission. What should have happened was the moment the applicants saw the matter that their substantial redress has been awarded, the matter should have been removed from the role, from the urgent role, and the issue of cost should have been enrolled in it.
I see. So your argument is that the matter has become moot?
Indeed, my lady. The moment the substantial redress was afforded, the matter has become moot. And for that reason alone, my lady, it should be struck for urgency.
And cost?
My lady, if a matter is struck for urgency, then the cost should follow. Lady, if the court does not make a determination on the merits, however, grants the urgency and cost is the only thing that remains, then that should go to the opposed court, my lady. Now, my lady, also I stated that on that reason alone, the matter should be dismissed, should be struck for urgency.
Yes.
Lady, that's not the only reason, and that's clear from the answering affidavit, and that also relies on the matter of Mogalakwena local municipality versus the Provincial Executive Council of Limpopo, where, my lady, it says, the judge stated, it seems to me that when urgency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at a hearing in due course. My lady, that has become moot. That is the argument there. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. And my lady, for that reason, the application is not urgent. But, my lady, the matter, the judge proceeds and says, once such prejudice is established, other factors come into consideration. These factors include, but are not limited to, 1, whether the respondents can adequately present their cases in the time available between the notice and the application. My lady, that is a point taken, and I understand that your ladyship believes that was the only point taken, but that is the extreme urgency argument.
Yes.
My lady, it then proceeds to say other prejudice to the respondents and the administration of justice, which may include the hearing of a moot matter, my lady, the strength of the case made by the applicant, and any delay by the applicant in asserting its rights. So, my lady, the argument for urgency is actually quite succinct, my lady. The horse had bolted when the first respondent complied. My lady, costs should not be awarded against the respondents for the conduct of the first respondent. It was on their database that the changes were made. And that's now being placed at the door of the third and fourth. But, my lady, I'm running ahead, arguing costs already when the issue of urgency is still before court, my lady.
Yes. Let me be very brief and frank on this issue. This matter is certified as urgent, and I will deal with it on that basis.
As it pleases you, my lady. My lady, I believe then we will have to proceed with the points in limine being the issue of locus standi.
Indeed.
As it pleases you, my lady. As they are effectively my points in limine, I'll need to start, I believe. And
Yes.
simply need, as it pleases you, my lady. And my lady, the first point in limine, that's at paragraph 5, is the issue of locus standi. Now, my lady, it states in the affidavit that the respondents deny the applicant's locus standi to bring this application. And the reason for that is clear, my lady. And it's very simple. The applicant applied, and that's at 5.2, in the liquidation application for leave to intervene. Now, my lady, it's common cause that that judgment hasn't yet been handed down. So, my lady, at this stage, the applicant is not yet identified as a creditor. Now, in the founding affidavit, and I believe it was at paragraph 9, at paragraph 10, my lady. At paragraph 10, the locus standi of the second of the applicant is stated as, I am a creditor of the second respondent, which is evident from the allegations, and therefore I have locus standi. Lady, so the locus standi in paragraph 10 of the founding affidavit is bound to him being a creditor. However, him being a creditor is still at issue and still at question in another court. And that judgment hasn't been handed down, my lady. So for this court to find that he is in fact a creditor will be a finding on a question of fact which is pending before another court. I'll get to the issue of lis alibi pendens. My lady, at paragraph 5.3 of the answering affidavit, it states, it has not yet been found that the applicant is a creditor. I've stated that. He has not obtained leave to intervene. The application for leave to intervene, as well as the applicant's status as a creditor, forms part of the judgment. I've stated that, my lady. The applicant has always known this, and despite his knowledge being disputed as a creditor, and the fact that the application for leave to intervene was opposed by me, he still proceeded with this application. Now, my lady, his locus standi is at issue, and his locus standi is dependent on the finding of the other court in the, what I'll title, the main application. Lady, as it stands, this court cannot make a finding on his locus standi because that issue is before another court, and for that, I'll jump to paragraph 7, which is the third point in limine, which is the lis alibi pendens matter, my lady. Lady, it says the applicant launched an application to intervene to be identified as a creditor. The judgment investigating the question as to whether the applicant is in fact a creditor has been reserved. I've stated this, my lady. I don't want to repeat myself. 7.3, the same parties are involved, which is the applicant and the respondents, effectively the second respondent on which he bases his locus standi. The cause of action, my lady, it's effectively liquidating the second respondent, with relief which is sought, or at the very least, the status of the second respondent being to reflect its liquidation status. Lady, at 7.4 proceeds to say the application cannot be heard pending the outcome of the application, the main application in which judgment has been reserved. Lady, those 2 points are clear, and the applicant simply cannot be in front of this court on the assumption that this court will entertain him as a creditor when another court still has to determine whether or not he is in fact a creditor. My lady, that is, as I understand, the points in limine that need to be argued. The second and fourth were already fully canvassed.
Yes.
As it pleases you, my lady.
Thank you, Mr.
Thank you, my lady. My lady, on the issue of locus standi, may I just be allowed to refresh our learned friend, Mr. Van Niekerk's memory to what the law says. And I'm reading to your ladyship from Endless Precedents of Pleadings, 9th edition, by the Honourable Mr. Justice Harms from page 247, and this is the most recent publication, where the learned author says the question of locus standi is in a sense procedural, but it's also a matter of substance. It concerns the sufficiency and directness of a person's interest in the litigation to be accepted as a litigating party. In other words, in these circumstances where the specific relief is applied for. Then it says it is also related to the capacity of a person to conclude a jural act. Sufficiently of interest depends on the facts of each case, and there are no fixed rules. So it all depends on the facts before a court. And the quick answer is page 54. Page 54, 2 paragraphs. Paragraph 6.7. So what the applicant says to your ladyship, in the main application that served before the Honourable Madam Justice Judge, there's and subsequently before His Lordship Mr. Justice Morgan, I applied for leave to intervene in a total separate judicial platform that is in liquidation proceedings. And I've concluded various agreements with the second respondent, all of which are not denied. And that your ladyship will find in paragraph 5.7 on page 54. Now, this is of paramount importance what the applicant says. He says, as is evident from the notice of motion accompanying this founding affidavit, I'm also approaching this court for an order to finally wind up Tarionyx in the circumstances where Tarionyx is indebted to me an amount of 190,905 rand, which is the amount of funds that was invested and entrusted by me to Tarionyx for pakkies or parcels since June 2022, and in accordance with the joint venture agreement. I could not obtain a copy. And then it goes further. If your ladyship turn the page to page 55, paragraph 5.10, Tarionyx calculated and portrayed my total contractual profit on my total investment to be 431,750 rand. To date hereof, I've not received all the funds due to me in terms of the joint venture agreement from Tarionyx. Now, my lady, the fact that the applicant has engaged in this so-called joint venture proceedings, that's not in denial. That's not being denied at all. What is said is that this is a separate judicial portfolio in terms of which the applicant became a so-called joint venture partner. It's got nothing to do with locus standi. This applicant has a fundamental, a real and substantial interest in the manner in which the second respondent's status is concerned pursuant to the application that was initiated for its liquidation. So this point of locus standi, regard being had to the uncontested objective facts, we respectfully submit is misguided. It's fundamentally misconceived because it seems that our learned friends don't want to accept that on their version, more than 30,000 investors invested into the second respondent. He's one of the investors. That's never been denied. There's never any allegation that this is a bogus applicant with a bogus claim and he's before court for an ulterior motive or purpose. Not at all. So insofar as locus standi is concerned, the case that's been made out by the applicant, and may I just for purposes of completeness, just direct your ladyship's attention to paragraph 9 of the founding affidavit on page 14. More specific, page 15, paragraph 10, where the respondent, where the applicant says, I'm a creditor of the second respondent, which is evident from the allegations and the amendments contained in my founding affidavit in support of my application for leave to intervene, dated 8 September 2023. To avoid prolixity, I attach it to a copy of the notice of motion and my founding affidavit without the annexures attached to it.
Yes, and in any event, in terms of, well, it may be, beyond the scope of this application, but specifically on that allegation, in any event, in terms of 344, 345, does he have to prove any more? Does he have to be certified as a creditor in terms of the Companies Act?
It goes a step further. We're not asking your ladyship to pronounce on
Yes.
whether or not the applicant has a right or entitlement to intervene. That's dealt with by rules 10 and rules 12. So that's, our learned friend misconstrues the whole basis and approach. We're not asking your ladyship to pronounce on it. And that is where the whole lis alibi pendens argument falls away, because lis alibi pendens, it pertains to the same parties, the same subject of litigation, and the same relief applied for. This relief that the applicant applies for in this application before your ladyship has absolutely nothing to do with the liquidation of the second respondent. So the lis alibi pendens argument, my lady, is a red herring. It's got absolutely, it doesn't even find traction insofar as the common law is concerned. It is a dead horse and it cannot be flogged by Mr. Van Niekerk. This is a desperate attempt to avoid the consequences of the third and the fourth respondents' illegal and unlawful conduct. These points in limine, my lady, has no substance, and it's fundamentally misconceived. Your lady should proceed with the application, and your ladyship should dismiss these points in limine with costs. Those are our arguments.
Yes, on the issue of mootness, which was raised by Mr. Van Niekerk. I know it's on the merits, but I mean we've been touching on the merits throughout these proceedings. They seem to be overlapping in my view.
Yeah.
What of that? Since the relief that you're seeking is moot, because the relief that you're seeking, the substantial relief that you're seeking has been granted to you today, and costs are not urgent.
There are two submissions. One must ask yourself a simple question. What was the trigger event to this application? Was it the conduct of the first respondent, the second respondent, or any other respondent? What triggered this application was the conduct of the third and the fourth respondent. It was only coincidence.
But even with that, Mr. Borges, is the application not moot?
Well, as we stand today before your ladyship, regarding to what happened this morning, yes, we have achieved exactly what we had in mind in paragraphs 2, 3, and 4 of the notice of motion. But that doesn't mean the application itself became moot as a result of the one question: was the applicant entitled to initiate this application on Monday, the 18th? The question is yes. Did anything happen insofar as the status of the second respondent is concerned since this application was served on Monday the 18th? No, my lady, only this morning. That doesn't mean because a pure coincidence, which the third and the fourth respondents had no hand in, all of a sudden now, the costs and all the other aspects raised by the respondents simply fall away. I agree with your ladyship. Wasn't it for that coincidence this morning, which we brought to your ladyship's attention, this application would have been well and alive. But it seems that somewhere within the organizational structures of the first respondent, sanity prevailed and the necessary amendment was effected. But that doesn't do away with the question whether or not the applicant was in law entitled to initiate this application regarding to the conduct of the third and the fourth respondent. And this application is very much alive insofar as costs are concerned. And that, yes.
Why should costs be dealt with on an urgent basis? Well, Mr. Van Niekerk goes further to say costs are never urgent.
My lady, Mr. Van Niekerk is wrong. Costs remains with your ladyship's judicial discretion. There's not one authority, may I add, that I came across in more than 28 years, which says that costs can never be urgent. Your ladyship is saddled with this application today. Your ladyship has all the facts before your ladyship. Why should another court be burdened, especially in a busy division like the Northwest Division of the High Court, another judge, another resources to go through and trawl through all of this evidence, may I add, which exceeds 190 pages as we stand, just for the question of costs. Costs, my lady, remains a judicial discretion within the framework of what is before your ladyship. It would have been a total different scenario where your ladyship walked in today and say, guys, I'm sitting with 10 applications. I haven't read any of these papers. I believe from Mr. Boetes that the matter became moot as a result of something that transpired earlier this morning. Hence, I'm not prepared. I don't have the capacity all the time now to consider the issue of urgency. Go to the opposed motion for withdrawal. But that's not what happened. Your ladyship heard from 10 o'clock and we now at 11:30. All these submissions, all the arguments, your ladyship is well traversed of the facts of this matter, and all that remains is your ladyship should exercise your ladyship's judicial discretion without burdening another court with exactly the same set of facts. That's our argument insofar as that matter, that issue is concerned.
Yes. And therefore, what relief does the applicant seek?
We seek an order that the third and the fourth respondents be ordered to pay the costs of this application on the scale as between attorney and client, including the costs consequent the appointment of senior counsel. And where is that founded, my lady? It's founded in 2 paragraphs of the founding affidavit, paragraphs 21 and paragraphs 22. And may I add, my lady, if your ladyship turns to paragraph 21 on page 22, what is stated and what is deposed to under oath in paragraphs 21 and 22 are not in dispute. The third respondent does not dispute that he posted on social media platforms, and I'm arguing it on his evidence, which has an audience of more than 11,000 people, that judges of this division skrik skielik wakker and are corrupt and are tainted with irregularity. We say, the applicant says in paragraphs 21 and 22, this attack on the judiciary is totally unwarranted. It's unfounded. It should not be tolerated, specifically in the light of the seriousness of what this court needs to do and attend to insofar as the liquidation application is concerned. May I just highlight 2 or 3 aspects, which once again are common cause. On page 23, this is the third respondent's words. He says on page 23, right at the top, the ipsa verba is the assering van die sakeredding is wettig en geldig sedert 8 Desember 2023. Op 14 Desember hoor die regter, that's his lordship Mr. Justice Morgan, dat dit die geval is. Hy het nie op 13 November die rule nie verleng na 'n spesifieke datum wat deur wetgewing vereis word nie. Toe skielik skrik hy wakker, wat totaal onwettig is. How can the third respondent point a finger at the judiciary and make a submission in public that a judge of this division acts illegally or unlawfully when making orders which are relevant and which are prudent within the structure that we are dealing with? But then he says the following in the last paragraph of his publication. He says, soos very rude on my and Walter. Now, Walter, my lady, is the third and fourth respondent's attorney, Mr. Niedermeyer. Gesê, wanneer die media jou skuldig bevind, sal geen regter die bol sê om daarteen te beslis nie. Kom ons toets die regbank. Let's test the judiciary. Let's test the bench in Northwest en sien of hulle nog in regspraak belangstel. Then listen what he says now. Ek geniet hierdie proses terdee. So he's enjoying defaming the judiciary. He's enjoying defaming and put the judiciary in disrepute. How on earth and what ground of justification is there? May I remind your ladyship what he says in his answering affidavit. He doesn't absolve himself insofar as the applicant is concerned. He blames other people. He says, no, it's Media 24. It is the Liquidators. It's other people. Scondo. which prompted my reaction. And this reaction is a normal reaction which one should expect within these circumstances. Please, there's no justification for anybody who adheres to the rule of law in this country, the Republic of South Africa that we are living in, to attack the judiciary on this basis, which the third respondent did. But then he follows up in Sunday's newspaper, which is also common cause in paragraph 21.2. Listen what he says, and this is verba ipsima. He says in the Rapport newspaper, dis 'n korrupte mafia, wat hier optree. Die liquidateurs, saam met die meester van die Hooggeregshof, saam met judges, wat in 'n korrupte sameswering hier betrokke is. So what he says is that the bench, the judiciary, is tantamount to the mafia. They all corrupt, they've colluded behind closed doors under a dark space in some obscure place.
Yes.
They've conspired against him. On what factual basis?
Yeah.
And then
But
the British returns.
Yes, I see that, Mr. Portis. But then the sum of your submission, as far as costs are concerned, is that the third and fourth respondent should bear the costs on a 10 inclined scale, and that is your basis for that.
Yes, and one further submission. Why did the second and the third why did the third and fourth respondents oppose the relief which the applicant seeks against the first respondent? Why? On what basis? I mean, it's tried. It's simple. This is standard 1 maths. This is not rocket science. I mean, there's an act that says you can't do certain things. Why oppose this application? Why burden your ladyship with papers exceeding 90 pages, and it's all these shenanigans and it's all these red herrings? No.
If there was substantial redress which could be provided and which was provided, isn't the answer then on Mr. Van Niekerk's submissions that substantial redress was provided by the first respondent and not the third and fourth respondents, if I understood his submissions correctly? Then why should they be burdened with something that ought to have been done by the first respondent, which they did?
That's because of the trigger event. His clients are the authors of this misfortune. Nobody else forced their hand to sign a resolution illegally and unlawfully. Wasn't it for that, we wouldn't have been here. Why? And there's no explanation, Your Ladyship, except for the attack on the judiciary. And that's the reason why they should have been brought to task, been brought to book. You cannot allow a situation where people act in this regard and then they say, they're not prepared to say, sorry, mea culpa, please excuse me. No, they go forth and there's this blame-shifting exercise hanging out of dirty linen and this attack on the judiciary, which we respectfully submit. There's no place in the laws, the sphere of law, that we are within what we are experiencing in South Africa today, because the message is sent out. If a judgment doesn't go in your favor, then you can go out on a public and a social media platform and defame the judiciary. Say to them whatever derogatory remarks you want to say. You won't be held, you won't be brought to book. They must be held responsible, because this is simply unjustified. And wasn't it for their conduct, this application would never have seen the day of life. That's the reason why they should be ordered to pay the cost of this application. Not the first respondent, not the second respondent, the third and the fourth respondent. Those are our submissions.
Okay, Mr. Portis.
Thank you, my lady.
Yes. Yes, Mr. Hashimson.
My lady, 3 points, and again to be brief. Allow me to point out the irony in the Respondents' arguments. On the one hand, they recognize the judgment being reserved, and on the other hand, when it comes to filing the business rescue application, there was no liquidation and this judgment is suddenly ignored. Very ironic how the third and fourth respondents adjust the field to meet their game. The second point, Melody, and this is maybe a point just to put the proverbial cat amongst the pigeons, and not to proclaim to be clairvoyant or prophetic, but Melody, I suspect in the absence of a finding by this court that that resolution was illegally filed. That we will not have heard the end of Mr. Liebenberg and his proverbial shenanigans. I suspect that the media might be filled with assumptions about no judgments or orders being made in this regard, and that this might protract things further. As Mr. Botha points out, there are about 30,000, if one is to believe Mr. Liebenberg's version, about 42,000 investors, 2.6 billion rand on their version. One of his employees seems to think it was about 4.4 billion rand which went through the scheme. We're still investigating that. But this obtains quite a high readership in the newspapers, unfortunately. Mr. Liebenberg's closed Facebook group at one stage reached 80,000 people. So we would submit that any order that is made by this court has to be clearly and unequivocally made, because it will end up on Mr. Liebenberg's, in parenthesis, closed forum, which has several tens of thousands of viewers, and it will be interpreted in his rather generous interpretation that he applies to these things generally. So I would submit that we can't simply assume that the order is moot or the relief is moot. It's unfortunately going to fall on deaf ears insofar as Mr. Liebenberg is concerned, and we would submit that your ladyship should make an unequivocal finding one way or the other. And then as far as costs are concerned, lady, I support Mr. Botha's contentions. If it were not for Mr. Liebenberg and Ms. Kleinhans's sleight of hand in filing the business rescue resolution as they did on the 6th of December, a fact they only chose to reveal the following week. And rather conveniently, I would not have given up my holiday, your ladyship would not have been entertained by Mr. Botha's argument, and we would not be sitting here. And in those circumstances, I would submit that the appropriate parties to be ordered to pay these costs would be the third and the fourth respondents only. And those are the submissions on behalf of the jointly appointed liquidators, my lady.
Thank you, Mr. Hershenson.
May I please, my lady?
Yes, Mr. Van Dyker.
My lady, it seems we've now gone to closing the issue of costs, not having regard to the points in limine, which your ladyship will no doubt find on. My lady, if I may only respond, as we are still on the issue of points in limine, I know the allegations were made for costs. Lady, the first question that Mr. Botha asked is why would we oppose, or why would the third and fourth respondents oppose? My lady, if your ladyship reads Prayer 5, it's clear that costs were sought even in the event of non-opposition. My lady, usually when one does not want such opposition and wants to ask the question why oppose, my lady, that clause, the catch-all clause, only in the event of opposition is inserted in such a prayer. My lady, you have to oppose proceedings when costs are sought against you. That's the first thing. The second thing, second point, my lady, the trigger event. Now, my lady, we're dealing with many trigger events seemingly. It seems that the registration of business rescue was a trigger event. However, from the affidavit, it seems that the first respondent's registration of the second respondent as in business was the trigger event. It was only when that registration changed that the matter had to be enrolled. Lady, whatever the trigger event was, the fact is it lies with the first respondent, not with the third and fourth respondents, because the first respondent was the party who did not amend the documents to reflect as in liquidation or provisional liquidation or whatever, my lady. The only party who has access to that system, which has made the relief moot, is the first respondent. My lady, as for the allegations of defaming the judiciary, that's wholly irrelevant to this application. This application is restricted to the respondent being listed as in liquidation. Lady, one's statements regarding someone who's not the applicant should not be used by the applicant to obtain costs for the applicant. Now, my lady, again, it's denied that those statements were defamatory. That's set out in the answering affidavit. It's explained. It's contextualized, my lady, but that's besides the point, my lady. It shouldn't be used as a crutch to obtain costs where the applicant doesn't have a basis to obtain costs for enrolling this matter, which has respectfully become moot. Lady, my final point, only the irony, insofar as it might relate to the merits, if the Lady Chippers want to hear that, where my colleague Richardson said there's irony in admitting the liquidation, but at another stage stating that it's not liquidated. Maybe there's no irony, and the field was not adjusted as he stated it. The question is whether the liquidation, the question isn't whether the liquidation was granted, it's whether the rule nisi was extended. So, my lady, on the one point, it's admitted that there was such an order. On the other hand, it's stated that the rule nisi was not extended. Lady,
but even if you consider the answering affidavit, that there wasn't such an order, and secondly, that the rule was not ended. If you consider that even the very order is denied.
My lady, and then the respondent goes into detail and says, I will request the record to show that I'm correct. That order wasn't made in court. But that's besides the point, my lady. Concern in that regard is only whether the applicant should be entitled to costs for a statement it finds defamatory, which in context, it seems to me not to meet the elements of defamation. Nonetheless, my lady, costs of an application which has become moot, and my lady, if I may only refer, I won't, this would be my last point, my lady, I don't want to take more of the court's time, we've taken enough. The matter of Laggar, L-A-G-G-A-R, versus Shell Auto Care Pty Limited, my lady. It's a 2001 matter, and it is in the Cape Division. My lady, if I may only read what the judge said in that regard, and then I'll rest with my submissions. Lady, at paragraph 4, he says, as 6 November had been allocated on the basis that the matter which was to be heard was one of urgency, and as the urgency had fallen away, there was no need whatsoever for it to have been heard on that date. In persisting with the matter in respect of the costs only, the parties may well have deprived other litigants with far greater claims to urgency from obtaining a hearing on 6 November. Why the legal representatives did not agree to postpone the matter to a date on the normal opposed roll in order to argue the question of costs is not clear or understood. And then he proceeds, my lady. He says, I trust that my remarks in this regard may ensure that this sort of benign neglect does not recur. Lady, so that was the case law that I referred to previously when I said the case law says that it has to be moved to the opposed roll. Lady, those would be my submissions in that regard.
Thank you, Mr. Van Niekerk. The following order is made. This matter is found to be urgent. 2, the points in limine raised by the 3rd and 4th respondents are dismissed. 3, the resolution adopted by the 3rd and 4th respondents on 6 December 2023, in terms of which the 2nd respondent voluntarily commenced with business rescue proceedings and placed the 2nd respondent under supervision, as provided for and envisaged in Section 129(1) of the Companies Act, number 71 of 2008, is set aside. 4, the 3rd and 4th respondents shall pay the costs of this application in their personal capacities on attorney and client scale, which costs shall include costs consequent upon the employment of senior counsel. That is the order of this court.
May it please the court, my lady, may we be excused?
You may be excused, Mr. Portis.
As it pleases the court, my lady.
You may be excused. May we take a 5-minute adjournment? We will resume at, let's just make it 10 minutes. We will resume at 12 o'clock. Court is adjourned.